out. Our toes and our fingers are cold tonight, but our hearts are warm. And we want it to be known that, according to the weather report I heard on the way over here, that we are not really supposed to be standing outside for any more than a half an hour at a time because it's a health and safety issue. But for those of us who care about health and safety, who objected to the use of our salt mines to serve as a highly pressurized gas station for frack gas, we find ourselves on the receiving end of some health and safety issues here, because in order to gather together, we've been locked out of the town of Reading courthouse. And so our theme for tonight is injustice at the court level, both what's happening inside to our defendants and Seneca Lake defenders, and also what's happening to us outside here. I always wanted to be the backup singer for legislator Martha Robertson, and I finally got my chance to open for her. So here is our star speaker of the night, Martha Robertson. We're so glad that you are here to bear witness to what we're doing together.
Sandra, I think that segue from health and safety of standing outside to health and safety of gas-free, of the Crestwood project and what's happening and will happen to Seneca Lake was maybe the best segue I've ever heard. But it is really true, and this is an issue not just for the people of Schuyler County or the people who border Seneca Lake directly, because frankly in upstate New York and the Finger Lakes region, we are all Seneca Lake. We are all Seneca Lake. And I come from the Tompkins County Legislature with the resolution that was passed in October 21st, supporting gas-free Seneca. I'll just read the end of it because it is too cold to stand out for long, but it is the opinion of the Tompkins County Legislature that this project, in particular, the dangerous, the likelihood of a catastrophic accident during the next 25 years, if this project goes forward, this would significantly damage the watershed of Seneca Lake in particular, and the viticulture, tourism, and economy of the Finger Lakes region as a whole, including that of Tompkins County. So resolved that the Tompkins County Legislature joins other municipalities, many other municipalities, in respectfully requesting that the New York State Department of Environmental Conservation withhold or rescind approval of any plan for gas storage adjacent to Seneca Lake. And I just think this is what our government is all about. It's about analyzing the issues, looking at competing demands, and deciding what the right thing is, and the right thing for the most people, and for a sustainable and long-term future of our communities. And it is time for all of us to stand together, because we are all Seneca Lake. Now, with Justice Berry, I have to say, we have a lot of public buildings in Tompkins County that the Tompkins County Legislature owns and operates and maintains, but it's not the county government's buildings. They're the people's buildings. Right. This is the town hall of the town of Reading. The taxpayers paid for this building. The taxpayers are heating this building, and it's warm inside. The taxpayers have the lights on, and they're paying the sheriff's deputies who are following the orders of Supervisor Schweitzer that says, this is actually not a public building tonight because the members of the public who are here are not allowed. I have to point out that, I just think that is an abuse of power. I would also point out that Justice Berry, who is, at least tonight, has let some observers into the 5 o'clock proceedings. We'll see what happens at 7. Perhaps he checked the state laws of New York State, because in the general laws of the state of New York, under the Judiciary, Article 2, Section 4, called Sittings of Courts to be Public. I will simply read Section 4. Sittings of courts to be public. The sittings of every court within this state shall be public. and every citizen may freely attend the same, except that in all proceedings and trials and cases for, see if this one fits, divorce, seduction, abortion, rape, assault with intent to commit rape, criminal sexual act, bastardy, or affiliation, the court may, in its discretion, exclude therefrom all persons who are not directly interested therein, excepting jurors, witnesses, and officers of the court. I don't think Gas-Free Seneca, I don't think We Are Seneca Lake fits within those exclusions. Therefore, it pertains, the sittings of every court shall be public and every citizen may freely attend the same. It is important that everybody knows that. It is vital that the public ask, what is Justice Berry afraid of? It is time for the public to see what's happening here, and it's time for the public to be allowed in without reservation. Thank you, Sandra, for inviting me tonight. Keep it up. Thank you so much.
Get you a We Are Seneca Lake t-shirt.
Wearing the lake.
Paul Passavant, who is not only a defendant and a Seneca Lake defender, but also a professor of constitutional law at Hobart and William Smith Colleges, who very graciously lectured Justice Berry on some fine points of constitutional law and enlightened us all, is here to tell us more about the problems inside and outside the courtroom with lawlessness.
Thank you, Sandra. It's a pleasure to be here with Martha Robertson and Sandra Steingraber. I just want to note that 3 weeks ago on December 17th at 5 o'clock in the evening, I came down here with defendant Laura Salamandra, but I was stopped at the door to the courthouse and I was prevented from going in. Only the defendant and her legal advisor were allowed to enter into the courtroom there, and that, and so we had court proceedings and it's a fundamental aspect of our legal system that those court proceedings should be open to the public. I have here a particular Supreme Court decision, so we're quoting law today, and in Richmond newspapers versus the state of Virginia, the Supreme Court noticed or argued that a trial courtroom is a public place where the people generally and representatives of the media have a right to be present, and where their presence historically has been thought to enhance the integrity and quality of what takes place. We were excluded from that courtroom 3 weeks ago, and we have reason to be questioning the integrity of those proceedings that took place when the public was excluded there. Now, the DA's office did have somebody in there. Assistant District Attorney Tunney participated in that, and he should know that a trial is supposed to be open to the public. He has a law degree, and so that means that he is knowingly violating the rights of the people by excluding the public from that courtroom. This means that the DA's office is poor stewards of the public trust. Now, Town Justice Berry has no law degree, and so he is apparently unaware of the most fundamental rights of the people in our system. Now, the right to counsel presupposes that a judge is going to understand the legal arguments that are being made to him or her. But when the justice does not have a law degree, we don't have that assurance. And it is constitutionally troublesome that a judge without law training might be sentencing people to jail. That's entirely problematic. And what are we to make of the DA's office appearing to direct the judge and the deputies in the courtroom? A party to a case, an interested party, is acting as judge. That's completely unfair, and it presents the appearance of a lack of judicial integrity in this court. The people in this town, this county, this region are poorly served by the legal system that we are witnessing here. If this government in Reading and Schuyler County is anything like what we have been seeing in these proceedings, then I've got grave doubts that this government is a secure repository of the public trust with respect to the Crestwood Project, to score volatile gases in salt caverns, on the shores of Seneca Lake. What I've seen is that the government here is more interested in protecting corporations than the rights and the welfare of the people who live here. And we can see the very low regard that the government and the town of Reading and Schuyler County consider the public, because they've left the public out in the cold. And that's where we are right now.
Well said, well said.
Travesty.
Comments
What would you
from
say
members of
about-
the press?
What's that?
Comments and questions from the press.
I'm curious why they wouldn't allow us to go in and have our press conference in the lobby.
I asked the deputies. They had no reason. They were told.
Kangaroo court.
They were told by Supervisor Swetzer that was the rule.
It sounds like other people have been allowed into this public building, but it seems like this is just vindictiveness that is targeted against We Are Seneca Lake as a particular political group. That's not a valid governmental objective, and that violates our rights.
DA Tunney, we're out here in the cold. The people of Reading, they won't let us in this public building. Do you have a comment about that? They won't let us in.
Public building.
Nobody let us in the courtroom.
The courthouse is closed. Why?
They won't let us in. They have a sheriff blocking the door.
It's a secret court.
It's a kangaroo court.
Kangaroo court.
It's a violation of public rights.
The courtroom is open.
No, it's not. They won't let us in.
The foyer, there's plenty of room outside the courtroom. They wouldn't let us in.
And
They wouldn't give us a reason.
certainly when the court starts at 7 o'clock, it will be open.
No,
not the building.
I was told that it would be open.
Could you tell the deputies that it's supposed to be open?
We've had that conversation already.
We were just hoping for the civility of the town to let us have our press conference
Then you should talk to
inside.
the townsfolk.
We did.
Why did you participate in a secret court proceeding 3 weeks ago?
You're the district attorney.
Howard.
And nice car.
Okay, the fingers are gone.